Hi, this is Suzanne Bichard, instructor with American Institute for Paralegal Studies. The topic of evidence is one of the most important subjects that we talk about in advanced litigation class. And why is that? Well, when you're litigating a case, no matter what type of case it is, you have to be concerned about the rules of evidence. Let's say your legal team is representing the plaintiff in a civil lawsuit against a defendant. The plaintiff has to prove each and every element of the claim by a preponderance of the evidence. This is what we mean when we say that the plaintiff has the burden of proof. So, how does the plaintiff go about meeting the burden of proof? Well, she meets her burden of proof by presenting evidence that establishes that it's more likely than not that each element of the claim occurred. So let's talk about evidence. Two of the most important questions to ask about any item of potential evidence are, is the evidence relevant, and is the evidence admissible? If the evidence is not relevant, it's not admissible, and you don't need to go any further with your analysis. Rule 401 of the Federal Rules of Evidence provides that relevant evidence means evidence that tends to make a fact of consequence more or maybe less probable than it would be without the evidence. And Rule 402 states evidence which is not relevant is not admissible. But even if an item of evidence is relevant, it might not be admissible for other reasons other than relevance. Therefore, if you determine that a piece of evidence is relevant, your next step would be to see if there's some other reason besides relevance why the evidence might not be admissible. Rule 402 states all relevant evidence is admissible, except as otherwise provided by the Constitution of the United States, by an act of Congress, by these rules, or by other rules prescribed by the Supreme Court pursuant to statutory authority. What this means is that there might be other reasons why a piece of evidence that would otherwise be relevant could be excluded from trial. There could be a constitutional provision, a statute, a court case, or even another rule in the evidence code that prohibits a certain type of evidence for coming into trial. For example, let's look at just a few of the rule-based exclusions. These rules provide that the following types of evidence will be excluded even though they might be relevant. Evidence for which the probative value is substantially outweighed by the danger of unfair prejudice. Evidence of another person's character or trait of character, if that evidence is used for the purpose of proving that the person acted in conformity with the character trait. Evidence of subsequent remedial measures, that is, evidence that a party took measures to correct something after the damage leading to the lawsuit was done. Evidence of compromise or offers to compromise. This means, generally speaking, that evidence of settlement offers are not admissible. And evidence that is hearsay. Of course, this is not an exhaustive list of all the types of evidence that may be excluded under the various rules of evidence in spite of relevance. There are others, and these are just a few of the examples. It's also important to keep in mind that there are exceptions to the general rules concerning the exclusion of each type of evidence. The important principle to keep in mind is that only relevant evidence is admissible at trial, and even evidence that is relevant might be rendered legally inadmissible. Litigation is a very exciting and fast-paced area of the law. Paralegals who work in this area get to work on fascinating issues every day. If you're not currently a student at AIPS, and if you're interested in learning more about opportunities for careers in the law, please visit our website at aips.com.